Then comes a submission of no case to answer. At the end of the prosecution evidence on defendant's application or on its own initiative, the judge may direct the jury to acquit on the ground that the prosecution evidence is insufficient for the reasonable court properly to convict, but must not do so unless the prosecutor has had an opportunity to make representations. This is known as a submission of no case to answer, and is only often referred as half-time submission due to the stage in the trial at which it is made. So after the prosecution evidence, the defendant can take plea that the evidence against him is not strong enough and does not hold any value, and it is so weak that no jury properly directed could convict. In this case, if the judge agrees, he will have the jury back and direct them to acquit, to return a verdict of not guilty. If he disagrees, he will have the jury back and the defense case will commence. Where two or more defendants make submission of no case to answer, defendant one's legal representative will go first, followed by defendant second's representative. The prosecutor will then respond and the judge will rule on the submissions. If the judge agrees that there is no case to answer on any count, he will ask the jury to return and direct them to return a verdict of not guilty on the specific count. The reason for this is that once the jury are sworn and in charge of a defendant only, they can deliver a verdict, even if, as here, they are told what that verdict will be. So even if the judge agrees to the submission of no case, it is the jury that has to direct to acquit, because now the tribunal of fact is jury in the Crown Court. So the judge will ask them to acquit, and the jury will acquit if the judge agrees to the submission of no case.